Good morning, everybody. Welcome to Pallas Attorneys HR Quarterly Updates, the third quarter already in the year 2022. And together, the quarterly updates, we are presenting it by myself, Alain Camonier, and Marcel de Vries, my colleague, sitting next to me. And we have some employment law updates for you. Can I have the next sheet, Marcel?
Certainly.
The topics we're going to discuss today are, by Marcel, the new Act, Transparent and Predictable Working Conditions. That's one. Marcel will also discuss case law with respect to Me Too. And of course, that is a serious topic, and a lot is going on, especially also in the media. With respect to recent developments, Marcel will talk about instant dismissal for the Supreme Court came up with a latest case law decision. And I myself will give you an update on some issues, employment issues or employment related issues, I must say, which originate from the financial state opening of Parliament, the third Tuesday in September. In Dutch it's called Prinsjesdag, so it's more financial, economical, tax-based, but there are some issues which have their effect on employment law. Another topic I'm going to discuss is the audio recording of meetings, or especially the secret audio recording of meetings, so employees who secretly record a meeting with their employer, for example. And with respect to recent developments, I will talk about the bill which is at this moment pending in Parliament, especially within the Senate, Eerste Kamer in Dutch, and that is the act with respect to working from anywhere, so employees can request to work wherever, so to say, that is from home, but also anywhere in the European Union. Still a bill, but I think very good to understand that that is happening at the moment. This was the introduction, and I think I'll give the floor to my colleague Marcel for the first topic.
All right, thank you very much, Alain. Let's move on to the first slide. And maybe before I do so, please, if you do have any questions, there is a possibility also to raise these questions. And at the end of our webinar, we also try to come back on the questions that you may have. The first topic that I would like to address is the transparent and predictable working conditions. And I think we also gave you an update in an earlier session that we had with an earlier webinar. So I'm not going to repeat it all, but the main change in the meantime is, of course, that we were still speaking about a directive that we had at that time, which resulted in a bill. But as from the 1st of August this year, there is the Act on Transparent and Predictable Working Conditions. So in Dutch, de Wet Transparante en Voorspelbare Arbeidsvoorwaarden. So now we're not talking about, okay, this may happen, it's now a law, and we simply have to deal with that. And the main reason for having this new legislation in place is actually that there should be more clarity, one said, about employment conditions for employees. Also, another reason was to have more safeguards in place for employees working on flexible working contracts. And also, the other reason was to have more flexibility for employees to have more employers. And that actually resulted in 3 key changes, and one of them is relating to the provision in relation to ancillary activities, which is in principle not possible anymore unless there is a justification for having that. Second one relates to mandatory training and also the use of study cost clauses in the employment contract, and the last one relates to the extension of the information obligation for the employer. Well, actually, this week we, at least as lawyers, we got a small present because the first case law actually arises in relation to the Act on Transparent and Predictable Working Conditions. So that's also the reason to discuss that one because it's relating to the first topic that I mentioned regarding the ancillary activities. So in this situation, we were talking about a court decision quite recently, 6th September, relates to an employee working in a role of service support. And this employee was already working for a couple of years with the company. And part of the employment contract was that there was a side activities clause in the contract itself with a penalty clause. So this employee worked for the company, but in addition, she also had her own Airbnb, and she also worked in some admin work for her husband, actually, who had some companies. So that was her extra work that she did. Well, at a certain moment, there was a breach of trust between the employee and the employer. The main case was actually more about whether the employee resigned or not. Well, on that point, the court was very clear. No, the employee did not. Came up with a very clear statement that that what was aimed at the termination of the employment contract. So on that one, the employee was on the good side. Then the other question was what to do with the claim of the employer in relation to the fact that the employee was doing side activities and that you could have been in breach of the ancillary activities clause. Well, on that one, actually, the court is going to discuss in the decision also the points that we have addressed also in earlier webinars, and that, the starting point for this is that such a clause is invalid unless there is an objective justification for having this clause and keeping this clause in place. And that could be, for instance, the fact that there is a need for the employer to protect confidential information, to avoid conflict of interest. Health and safety can also be a reason. And another important reason can also be that you cannot be in violation of legislation. So for instance, also a Working Hours Act as an example. So in this situation, also these justifications were also mentioned by the court. And at the end, the court came to the conclusion that the employer did not make clear that there was any objective justification for actually invoking this side activities clause. So at the end, there were also no penalties due. So the other component I already mentioned briefly, and I'm not going to discuss it in too much detail, but is of course the mandatory training and also the use of the study cost clause. Just to refresh your memory, we have a new provision in Dutch law, which I've also stated on one of the slides. And the main aspect is that you should always be careful with whether the training is mandatory or not. So if we're talking about mandatory training, and then the starting point is that there are no costs involved for the employees. So not only relating to the training itself, but also, for instance, travel costs that may incur, study materials, examination fees, etc. And so that's something to take into account. In addition, it's also important that the time which is spent on the training, that should be regarded as working time. But that's already a more difficult one because, how to deal, for instance, with preparation time. I've also heard a story of one of my clients who said, well, there is one of our employees is doing a training which is quite intensive, and that will take him, well, at least a weekend, a month to prepare. Is that also something we should consider as working time? Well, on that part, the answer is actually it's not fully clear yet how to deal with that situation, and whether that should also be considered as working time. Well, in addition, the training should also take place during working hours, as far as possible, of course. And that also means that you have to keep a close eye on your study cost clause and also maybe the arrangements that you have in place, because these may no longer be enforceable if the starting point is that you're trying to set off costs which should actually be borne by you as employer. So mandatory training is not always clear, but what we do read on the information that we do have is, of course, and that it relates to training that the employer is obliged to provide to the employee in order to make sure that he can do the work or she can do the work which they need to fulfill. And that's of course already also pretty broad. So if we're talking about a pilot who needs to have certain certificates in place, well then it's maybe quite obvious that these trainings should also be considered mandatory. But if someone would like to have a promotion and for that reason he would like to do a certain training or study, well, I said already, something you should consider also as part of tasks and responsibilities of the employee, because maybe it's not mandatory if you look at the current position of the employee. And so that's something to keep in mind. And also when we talk about mandatory training, this is also when we talk about, for instance, a training that you need to offer as part of an improvement plan or as part of efforts that you have to make to try to replace an employee. And so that's something to still be aware of. Well, then the last component is, of course, the full list with additional pieces of information that you should provide to the employees at the start of the employment. I'm not going to run through all these topics, but maybe it's good to know that in the meantime we also received some explanations from our minister because there were quite some questions about how to deal with providing this information to the employees. And on the pieces that I also highlighted in bold, for instance, the paid leave, is it really necessary to give all the pieces of information to all types of paid leave that we have in the Netherlands? Now, on that part, also the minister said, well, that's not really necessary. So you can or either refer to your employee handbook, if that contains a very clear provision about the various types of paid leave that you may have, and we have in the Netherlands, of course. Or you can also refer to the legislation in place. So you don't need to spell it out in detail. And that's actually also the case for the information that you should provide on the procedure regarding termination of employment. So our employment law is not the most easiest one, I think, in Europe. So you don't have to give them a sort of a training how it works under Dutch law to terminate the employment contract. And that's also something which has been clarified by the minister. So you can make a reference to the relevant parts that we have in our Dutch civil code, actually, without spelling out all the details. And so that's making this point a little bit easier, and that's, I think, good. And that actually also applies to the notice and the probationary period, that you can simply refer to the statutory provisions that we have in place. So if there is information that you can already refer to because it's part of a collective labor agreement, then it's also possible that you can refer to this collective labor agreement. So that's also something to keep in mind. Yeah, we've been reviewing and adjusting employment contracts and handbooks for quite some clients already. So if you did not already do this exercise yourself and you still need some support on that, well, please let us know, because it's still important that you are compliant with the new legislation, of course. All right, then I think I'm going to give you the floor back.
Yeah, thank you. Before I start with my first topic, we have a question, and the question is, what are the ECLI numbers of the case law, which we are talking about during this session? And the presentation will pop up on our website after this this webinar, and we will make sure that all the ECLI numbers, so those are the numbers with the court, where you can find the case law decisions by the court, we will mention those on our website. And if we do that on the sheets, then you get all kinds of numbers and letters, which is not very handy to look at. So we chose to do it in this way. So after this webinar, please have a look at our website. What I'm going to run you through now is something which is not so much employment law, but those are the issues, some most tax-related issues, which have their effect on employment law. And those tax-related issues, they were mentioned in the financial state opening of Parliament last week. It simply, in the Netherlands, it simply says this is what we are going to do in the Netherlands with respect to our financial situation in the Netherlands, and with that financial situation connected to that is of course the tax situation. So I've chosen to discuss 3 issues from this financial state opening because they have more or less an impact on employment law. And the first one is the change the ministers created on the 30% tax rule. And most of you will know that when you hire someone from outside of the Netherlands, so that person is recruited from outside the Netherlands and from a place more than 150 kilometers from the Dutch border. At that stage, when you meet all the criteria, the employee can apply for the 30% tax rule, which more or less means that only 70% of the gross salary is taxed and 30% of the income is not taxed. And the idea behind that is to make the Netherlands an attractive place for knowledge migrants to come to work in the Netherlands and to bring their skills to the Netherlands to help the Dutch economy grow. That is a rule which exists already for decades in one or other format. But as we all know, we are at the moment experiencing all kinds of issues with respect to inflation, with respect to savings. And also there is a negative sentiment with respect to immigration, and that means that also the 30% tax rule will change, and that means that the rights and entitlements will decrease compared to what is the case at the moment. And that means that the 30% tax rule will, as of 2024, be limited to a cap, and the cap is the public sector cap, and that is the cap which exists in the Netherlands with respect to salaries for directors who are civil servants or work in healthcare, etc. And in the Netherlands that is also referred to as the Balken and the norm. Mr. Balken used to be our prime minister, and that was his salary. And it is within the public sector seen as not good to earn a salary more than the salary of our prime minister. In 2022, that is 260,000 euros per year. And now the 30% tax ruling will also be connected to this cap. And that means that when you hire someone from outside the Netherlands, the 30% tax rule will, as of 2024, only be a part of the salary until that cap. And every bit above that cap, so taking into consideration the 2022 salary, as from €1 above 216,000, that is taxed in accordance with the normal rules. Okay, that is then the situation. Maybe good to also understand that there is a transition period, and that means when the 30% tax rule exists in the last month of 2022, so when an employee already has the 30% tax rule in December 2022, then this cap will only apply per January 1, 2026. So everybody who has in 2022 the 30% tax rule will not be limited with respect to the public sector cap in 2024 already. So that might be a decision to take for employees and maybe also for employers when to hire someone in 2022 or on a later date. Something to take into consideration. Another issue, also a tax issue which has its effect on employment law, are the percentage changes in the work-related cost rule, in Dutch de werkkostenregeling. And there the percentages will change, and that means that the fixed exemption for the first 400,000 euros of the payroll for tax purposes will be set at 1.92% instead of 1.7% at the moment. And how does that work? It means that the first 400,000 euros which you pay as salaries as an employer, from that 400,000 euros, 1.92% can be used for expenses for employees, except for special exemptions mentioned in the law. But if you increase that amount, so you have more expenses than 1.92% over the 400,000 euros, at that stage you will get a tax fine of 80% of the costs you are going to reimburse to the employees. Be aware, we have some extra exemption amount available as from 2023. It's not too much, but it's something. Everything above the 400,000 euro cap will be still calculated as per 1.18%, and that's the same in 2022. With respect to employment law, we're talking about, of course, expenses made by or on behalf of employees. This also concerns, for example, the costs employees make for their lawyer in termination cases. So be aware, if you agree in a termination case on paying the lawyer's fees, that you should take into consideration what is mentioned in the work-related cost rule. So please take that into careful consideration. Another change in 2023 and 2024 is something which is mentioned in a lot of employment contracts and in a lot of handbooks personnel. For already many years there is an untaxed travel allowance of 19 cents per kilometer if an employee travels for work. 19 cents per kilometer can be paid to the employee by the employer without wage taxes having to be paid. This untaxed travel allowance will be increased in 2023 to 21 cents, so 2 cents extra, and that will be increased even further in 2024 to 22 cents per kilometer. Not a big issue from employment law perspective, because the employee will get more than he or she is entitled to in 2022, but be aware it's still a unilateral change of the employment contract. So we always say, if you change these kind of figures, also combine that with a unilateral change clause in the employment contract, because what will happen if in 2025 it will be decreased again, and in the employment contract you mentioned 22 cents, then you have a discussion about what is from tax purposes allowed and what is agreed upon with the employee. But for now, good to know that you can pay more travel expenses to the employee per kilometer driven. And the last issue, maybe not a big one, but for employers who provide electric vehicles to employees, it is a tax compensation which should be paid by the employees. That is the addition to the income tax percentage for electric cars, and 16% will of the value, the listed value of the electric car until 30,000 euros will be added to the income of the employee, and taxes should be paid, but that's 60%. And over 30,000 it is 22%. So that is a cap of 5,000 less than 2022. So the government is not going to support the electric vehicles in the same way as before. That is different, just to know, with hydrogen cars and solar cars. I don't know anybody who has a hydrogen fueled car or a solar car, but in the tax rules it says that those cars 0% taxes or 0% will be added to your income for tax purposes. So it might be an idea to look at it, but I didn't even know that you could buy those. This with respect to Prinsjesdag, so to say, and I'll give the floor to Marcel again for the next topic.
Thank you, Alain. Well, then it's, of course, very easy to create a small bridge to this next topic, and that is Me Too. Me Too is a lot of cases are going on at the moment in relation to Me Too, also in our own practice, and especially after we had, of course, the whole situation in the Netherlands in relation to the Voice of Holland. Then, of course, we also had, for people who are not from the Netherlands, the case where the director of Ajax came in the news in a not very positive way in relation to inappropriate behavior. And so that also made that this is still quite a hot topic in employment law. I would like to touch on briefly the employer obligations before I also jump on what we see in case law. And if you look at the employer obligations, then it's good to understand that there is a duty of care for the employer to make sure that you provide a safe working environment to employees. That's the starting point in this discussion. And that also means that you're obliged to take measures and also to take preventive, protective measures if that is also necessary and if the situation is asking for that. That's based on ARBO legislation, so the working conditions legislation that we have in place, and also to be more specific on the Dutch Civil Code. I also named these specific articles for the people who want to look at these articles in our Civil Code. So in relation to the fact that you do need to provide a safe working place, and also more general that you need to act as a good employer, and if you don't, that can also result in the fact that you can be liable for damages. If we talk about inappropriate behavior, and we're also looking at what is the definition, for instance, that we can find on that one. Well, not specifically to inappropriate behavior, but there is a definition in the law in relation to sexual harassment, which says that any form of verbal and non-verbal physical behavior with sexual connotation that has the purpose or effect of violating the person's dignity, in particular when creating a threatening, hostile, offensive, humiliating, or offensive situation. And that already makes clear that the definition is quite broad, and that also makes that there are quite some situations where you may not think of, well, should that also be seen as harassment, but it is, or it can. And so, I also put some circumstances on the slide to give examples of how can you recognize sexual harassment. So that can be, for instance, when it relates to ambiguous comments or jokes related to sexuality or intimacy. It can also simply be making a comment about someone's clothes. That's a possibility. Staring at someone but it can also be, well, having a Friday afternoon drink and blocking the way for someone who wants to pass by. So that's all something where you can consider that as harassment or maybe also sexual harassment. Well, and of course not to speak about asking for sexual favors, and that's also what we have seen in some examples of the case law. Or, even worse, sexual assault or rape. More important maybe to emphasize the code of conduct that you should have in place, because that's, I think, one of the key aspects in this whole discussion. To have a clear code of conduct in relation to inappropriate behavior. And if you have a policy in place, then it's also very important to come up with examples. And of course, these examples will not be limited, but at least it's good to make this clear to employees and also to repeat once in a while that employees are aware of the existence of this code or this protocol. That's also something which is important that we see back in case law, where the employee sometimes says, well, there is no code in place. Okay, maybe there's a code in place, but well, it's already from 20 years old. So that's also something which may not help you in that specific situation. In addition to that, it's important to have a complaints procedure in place, so that you also give clarity on, okay, this is a process that we're going to follow, and this is also if you are in a situation as an employee where you can blame an employee for sexual harassment, or you are in a difficult situation in relation to inappropriate behavior, to put it in a more broad way, and that you can also fall back on this complaint procedure. And also that is clear for the person who is involved in that process, what the rules are that will be followed by the company, and that's absolutely key. In addition to that, it's also important to have a complaints committee, and if you have one in place, also pay attention to the composition of that committee, because in certain situations you may need to involve external parties to do the investigation or to support in the investigation. And sometimes we also see that still the manager of the employee who is subject to the investigation will be placed in such a committee, which is absolutely not helping in such a situation. You can also think of installing a trusted representative or counselor within the company, so in Dutch, vertrouwenspersoon, and also there you can either have an internal or external one, and it's also depending, of course, of the size of the company. When having these policies in place, it's also very important to keep in mind that the Works Council may also play a role in this, because this may have an impact on certain rules which may be linked to privacy issues, for instance. It may also be linked to complaint procedures. And so these aspects could also be the domain, depending on the precise content of the policies of the Works Council. And that may also mean that you may need to have the prior consent of the Works Council before implementing these policies. If we then look at case law, and there are definitely some considerations to take into account, and factors that the court also deemed very important in making a decision. And one of them is also, of course, the seriousness of the behavior, and whether that is willful, whether that's unintentional, that's also a possibility, of course. And so that, of course, plays a role in the assessment also that has to be made by the court. Position, the function of the employee involved is also very important, especially when there is a more managerial position where people may have more power, or where they may be considered to be more a role model for the company. So especially higher management, that's something which will be taken into account, and that you may expect that you will be an example for the company and that inappropriate behavior may also be sooner be considered something which is a reason to terminate the employment contract. There may also be mitigating circumstances, so maybe it's something where the employee seriously showed his regret, and that's a possibility that he had a long-standing good service with the company. So that's also definitely something the court will take into account, and the personal circumstances, I would say, of the individual. The awareness of the code of conduct that you may have in place. Sometimes we also see employees who are part of the investigation and part of a procedure with the court who say, well, this is simply how it goes within the company. This is our culture. We have Friday afternoon drinks, and then we go to pubs, and then things may happen, and that's already happening for quite a while. That's also a factor that may be taken into account. But also there may be clear boundaries of what is accepted or not. But this culture thing is a factor which will be taken into account by the court as well. And it also counts for the fact whether you warned an employee earlier or not, whether the complaint procedure has been followed. That's also a very key one. If you do have such a procedure in place, then it's also very important that you follow this procedure in a proper way. Because if you don't, then that's also very easy for the court and also for the employee who is involved in this process to say, well, you did not even follow your own process in a correct way. So now you can also not punish me in the way that you would like to do. Following a diligent process is also very important. How did the communication go? Sometimes we see cases where the employee is already blamed from the start, and it's very difficult to come up with a different story. Sometimes also where the employee does not have the possibility to involve his lawyer if he wants to. So all these aspects will also be taken into account to assess whether a diligent process has taken place. And that also counts in particular for a fair hearing. Did the employee who is subject to the investigation also had a chance to come up with his say on the situation? And because if that is not the case, and if this person is not heard in a proper way, then that could also be a reason to actually say that the employer did not a good job, and that could be a reason for not terminating the employment contract, or simply a reason for the court to grant a high compensation, a fair compensation on top of the transition payment. Another aspect that may be good to take into account is also whether a complainant is still in service. So the court may take that into account as well. So in case the complainant is still on board of the company, it could also be a reason for the court to more easily decide to terminate the employment contract. Then still, that could be a reason to grant the compensation if the other circumstances give reasons to do so. But if someone is no longer on board, then that could also be a reason for the court to say, well, okay, but is this then serious enough to still terminate the employment contract as requested by the employer? So that's definitely also something to take into account. So bottom line, it's very important that you do pay attention to your company rules that you have in place. And that's also what we have seen, of course, with the situation of The Voice, also with the situation of Ajax, for instance, where attention is paid to the fact that there's no clear set of rules within these companies and organizations. And that's definitely not helping you if this is becoming a real issue in your organization. And so that's something to take into account. I think, conscious of time, I'm going to give you the floor back, and I think you're going to discuss with us the audio recordings.
Correct. Thank you, Marcel. What we experience more and more is that discussions in meetings are being taped are being recorded, whether by employers or employees. I even had an issue with in a courtroom a couple of weeks ago, where the judge also said who is recording this, and I want to have the confirmation that nobody is recording anything. And we all understand why, because with our iPhones and Samsungs, it's very easy to tape everything and to come back with these recordings whenever it suits you. And we even have cases in our own practice where we are being provided with hours and hours of recordings of secretly taped meetings, and then the client says, yeah, here it's all on tape, yeah, what to do with it and how does it work? But it is sign of the times. And there's case law going on. Dutch law says something about it, and you see that also case law provides some rules how to deal with this. So I want to take you through that. To start off, when you as an employee or even employer, as a person, make a secret audio recording of a meeting during which you are not present, so you leave your audio device or your phone in a room and you leave the room, be aware that that is a criminal act. That is a criminal offense. The Dutch Criminal Code provides this in Article 139a, Wetboek van Strafrecht. So then you have an issue, because then someone has committed a crime, and you can deal with that. I don't see that happen often in our practice. We more see secret audio recordings of meetings where the person was present. As we all can imagine, when you secretly record something, there is also a privacy issue at stake. And therefore I refer to the GDPR, the General Directive on the General Data Protection Regulation, sorry, in the Netherlands, the AVG, which says that when you are using data which can be related or combined to actual persons, at that stage this regulation is coming into place, and more or less in a lot of meetings you can definitely combine the recording with the persons who are there, because of you know that everybody has its own voice. So that there is a discussion possible with respect to violation of GDPR is a situation, and can be indeed a thing. And for this I also refer to a case of 2022 where not the employee but the employer made a secret audio recording of an employee, and that employee had a call with a customer of the company. The company sold cars, and the employer had the idea that the employee was having a business on the side, so selling cars on its own and using the company or the company's assets and maybe even the company's customers for its own purpose. So it recorded a conversation, a telephone conversation between the customer and this employee, where indeed the employee tried to sell the customer not a car from the employer stock, but his own car. So not a car from a third party, but his own car. And that was a reason for the employer, this secret audio recording, to instant dismiss this employee. This came before the court in The Hague, and the court says, yeah, this is not how it works. When you, as an employer, record a meeting, or in this case, a phone call secretly, you have to take into consideration what is the goal of this recording, and there are other reasons or other measures to see whether someone is driving a business at the site. The other thing is it necessary to have these recordings? And necessary, that is a big issue, simply because what is easier than having a meeting with an employee with two persons? When you have two persons, then from an evidence perspective, you can prove what has been said. You can also make memo minutes from the meeting. So more or less from that perspective, you don't need a recording. But since this was a secret recording of a phone call, this was also a violation of the GDPR, especially the privacy of the customer was scrutinized, because the customer also didn't know that this call was taped, and therefore the telephone conversation could not be used by the employer to dismiss this employee. I think very clear. More in our practice, we see that employees make secret recordings. And in that perspective, I would like to refer to also a case before the Hague Court of late 2021. Was published in April 2022. And again, on our website, we will provide you with the A-clean numbers where you can find this, the full cases. And that was an employee who was not functioning too well. There were meetings, discussions going on about what he did not do well. It was an elderly care foundation, and this employee had some lack of skills. He was provided education, schooling. He refused to do so. Then the employer said, sorry, but if you refuse to do so, that can have its effect on your performance and therefore on the employment contract. Employee called in sick. Further discussions were going on, and then after the third discussion between employee and his manager, he said, I'm going to tell you that you have a bad case, dear employer, because I taped everything. So I can prove that you are pushing me and that I got ill because of this and all kinds of issues. The employer said, yeah, but if this is the situation, then there is a breach of trust. You disrupted the employment relation because of the fact that you secretly recorded our meetings. Long story short, the court agreed with that point of view and said, yeah, if you do it like this, the employee, then it's clear that there is a disrupted employment relation. That means that it creates a ground for termination, and therefore this termination ground leads to the termination of the employment contract, and which termination ground was created by the employee himself by taping secretly the meetings. So be aware, it is not always without consequences if employees tape their meetings, especially if it's done secretly. If it's not done secretly, if it's all in the open, why not? Of course. My last issue on this is be transparent on meetings, but also ask employees to be transparent on recordings as well, because it can have its effect on the employment relation and therefore also on litigation when necessary. Marcel, because of the time, I think we should hurry up a little bit.
Yeah. will do. All right. Well, this is of course quarterly update. So we like to discuss the most actual topics, and one of them is a very recent decision of the Supreme Court, so the highest court that we have in the Netherlands, and that's very recently, the 21st of September. And the quick question was actually whether the instant dismissal still could hold in a situation where the employee was dismissed, a project manager, and in the dismissal letter, the instant dismissal letter, it was stated that they could see on his car right registrations actually that he did not spend for at least more than 40 hours time on the work. So he should have spent the time, of course, on his work, and he did not for at least 40 hours. Then later on, it became clear during the whole procedure that it was only clear for, well, approximately 18 hours that the employee did miss actually and did not spend to his work. And then the key question was actually whether the instant dismissal letter, which stated the 40 hours, whether that fixes the urgent reason for termination, so that it also means that if at the end it seems to be 17.5 or 18, or whether there's still an urgent reason for the employer to fall back on. And in this situation, the Supreme Court has said, well, the literal text actually of the warning, of the dismissal letter, the instant dismissal letter, is not most important. So most important in this situation is that it was still very clear from the letter to the employee that this was an urgent reason for the employer to terminate the employment contract. The fact that he was for a significant amount of time not doing his work, but spending his time on different things. So whether that was exactly 40 hours or 17.5 hours, that was not a reason for the Supreme Court to say, well, in this situation, the instant dismissal will no longer hold. So it's still very important, of course, to pay attention to a proper and clear instant dismissal letter. That's key. Of course, you should also provide clarity on the existence of the urgent reason, and of course, it's very important that you inform the employee also instantly about the urgent reasons that exist. But this decision of the Supreme Court makes clear that they are a little less strict in relation to the wording of the instant dismissal letter. So that's something which is, I think, good and positive for our employment practice. And I think you are going to speak about the work where you want.
That's the last topic, so that's, I think, good from a time perspective. We're talking about a bill here, so it's not an act already, but something which likely will come in place. So let's see. It is based on the fact that we've seen that a lot of work is being done in a hybrid form. As of the COVID period, everybody is working from home or partly from home, and how does that work? The European Commission also came up with all kinds of memos and notifications that the future of the work is hybrid, so that every member state, every country should take consideration of that and do something on that. In the Netherlands, the SEG, the Social Economic Council, provided a full report on working hybrid, and that is also part of the basis of this new act, which is now before the Senate, which is the Eerste Kamer in the Netherlands. The Houses of Commons, Tweede Kamer, already accepted this bill. So if now the Senate also accepts this bill, it will become law in the Netherlands. and on the 27th of September, so the day before yesterday, the Senate was provided with new papers on this bill. So we'll see any moment what will happen with that. What does this bill say? What does this lead to? It is an act which is being called the Act Work Where You Want. So that means that the employee can make a request to the employer to work from a different address than the office, for example. And that is especially referred to the home office, or the home address of the employee. But the bill says simply the request can see to any place within the EU. And that, I think, is something which is not being thought of adequately enough. Because the employer must consider this request, the Act also says, and taking all circumstances into consideration, only if there are reasons not to agree with this request, based on reasonableness and fairness, at that stage the employer may refuse this request. So the employee can say, I want to work from home, but I want to work from my holiday or home in Spain or in Bulgaria or whatever. The cross-border issues we are going to face when this happens, and that there's one sentence in the whole memorandum which accompanies this bill or this act refers to this, is that when you work cross-border, we get all kinds of issues with respect to social security, because it's very clear that when working not from the company's address, but somewhere in, for example, Spain, it means that Social Security of Spain might kick in. Same counts for wage tax, and that means therefore that the employer should set up a payroll in, my example, Spain. In addition, the Rome 1 regulation, which deals with employment contracts, says that when someone is working normally, habitually in some country, which could be in Spain, for example, at that stage, Spanish employment law will be applicable, irrespective of what is agreed upon in the contract and what to do with all the issues you agreed upon in the Dutch contract. So I think that it is not a good idea to implement this act, or at least not in the form as it is. However, these international issues are not being considered easily by the parliament, so not talking about them at all, more or less. They simply refer to labor unions and to countries who should solve this problem. But for us employers, it's very good to understand that it creates some issues and it's not easily rejected. So please take into consideration that you should do something with this when the act will indeed come to life. Marcel.
Okay.
I think closing statements.
Yeah, closing statements. Is there time for one short question?
One question, and maybe that is for you, with respect to the study costs, which you mentioned, which you can't reimburse them with the employee. What about study cost agreements which are already in place before August 1?
Yeah, well, that's a very good question. Study costs already in place. Well, you still have to deal with the new legislation, but you may have a sort of a difficult situation with an employee just starting right before. So yeah, I think the new legislation is not giving full clarity on that one, but I think it's very likely to that the new legislation will also be applied on that one. Yeah. And so you have to deal with the new legislation as from the 1st of August and make sure that you are compliant with that.
Okay, yeah, not good news for... Okay, thank you.
All right. Well, if there are any questions which have not been answered, but which have been addressed or will be addressed during or after the webinar, we will come back to you for sure. So that's something we will do. We will send you also the slides and also with the updates on the numbers, the ACLI numbers. Then I think we come to an end of this webinar.
We have the information.
Definitely. We have a QR code which you can scan, and then we hope that you will also fill in our evaluation form. So if you would like to do that, that's also very good for us, and it will help us for next events. And then we also would like to thank you.
I think you should go to the QR code.
Yeah, that's the next one. The questions and the QR code. So here it is. It's in English, that's something which is easy to fill in, hopefully. Thank you very much for participating in the webinar. We hope you enjoyed it. And of course, we also hope that we can see you in the next event, webinar or seminar very soon. Thank you very much.
Thank you.